Good morning, everyone. We're going to give maybe a couple more seconds to allow people in from the waiting room. Looks like everyone is here. Welcome to the Wednesday Q&A for September 4th. Where's the summer gone? We're going to start with our usual Zoom housekeeping instructions. If you want to start or stop your video, or enter a question into the chat, that should be at the bottom of your screen, depending on which platform you use. We ask that everyone stay muted unless you're going to ask for clarification or ask a question. That way it reduces background noise for everyone and makes it easier for everyone to hear. Just a reminder again that this Q&A is for general discussion. It is not legal advice. So if you find that you're wanting to give us a large description of your governing documents or excerpts from your governing documents, that's beyond what we can answer in this forum, please ask your association attorney that question and they'll be able to give you an answer because they know the facts and circumstances, and they will have your governing documents available to give the answer for your particular association. And the reason why we have to say this is because some answers are different depending on what's in your governing documents. So again, this is just general information. It's not legal advice. There is, if you put a question into the chat, that also is not legal advice. We ask that you use the chat for asking for clarification or asking a question. It's not for discussion like you see on the CAI message boards. Moving on, the CTA is still being challenged at the national level. So we recommend waiting until about mid-October-ish to determine whether if you're if those efforts are going to be successful or not. And then as a reminder that for the CTA, this is national, not state. If your association does not want to participate, you kind of don't have a choice unless the challenges are successful. So please be aware of that. If you as a board member or your board members, if you're a manager, don't want to give that level of personal information, go on to FinCEN, FINCEN, and get a FinCEN number. That way the information goes directly to FinCEN. You're not having to give it to your manager or another individual. And then you just use your number for your identification. It's quick, easy, simple, and it means that you're compliant. CA Day is coming up. It's October 5th this year down at the Convention Center. It's a fantastic place to speak with vendors. We will have a booth there and our attorneys will be available throughout the day. There are educational seminars and it's a great place to meet people, get information on community association topics. Katie and Ken from our office will be doing a presentation on what you must do or can't do when Ukiwa is your statute. So that would be very helpful, especially since Ukiwa is going to be applicable to everyone starting on January 1st of 2028. Ken, did you have anything to add to that?
No, I'm good.
Okay, moving on to our first question. If a board dictates a new rule for the community in a community meeting that was not decided first in an open board meeting, is that valid? Our board does not hold open board meetings, no minutes are provided either, and then has informational community meetings to state their decision. I wonder if these decisions are even valid because the community never heard the discussion the board had or who agreed on it. I believe this is very unethical, but we can't get them to stop. So this particular fact pattern is too specific for us to address directly. In general, though, not all communities are required to hold open board meetings. It really depends on what's in your specific governing documents. It also depends on your governing statute if it's not directly in your governing documents. For condominiums, unless you have the requirement in your governing document stating that all board meetings must be open, they're not required to be. That will change on January 1st of 2028 when Ukiah becomes applicable to everyone. So the board, going on from that particular part of this, the board has the sole authority to adopt rules unless there are prohibitions in your governing documents. We have seen particular governing documents that will state that owners have the ability to vote on rules or vote to reject rules. It really depends on what's in your specific governing documents. That's one of the reasons why we can't completely answer this question. So the authority for rules is found in RCW 6434-304 sub 1 sub A and 6438-020 sub 1. So that is the new Condominium Act and the HOA Act. The new Condominium Act, that particular provision also applies to old act condos. So Ukiah has different regulations or different structure for rules. So the procedure required to adopt rules is found in 6490-505. And Chelsea, when you have a second, could you put those statutes in the chat, please? So for Ukiah communities now, this procedure applies. It'll apply to everyone starting January 1st of 2028. So how this works under Ukiah is that the board gives owners formal notice that they are wanting to amend or adopt or change a rule, including the actual proposed language. In that notice, there must be a meeting set where owners can give I'm sorry, my brain hasn't caught up yet. Where owners have the opportunity to comment, basically. So for that time frame, when the notice is sent out, and then at that meeting, owners must be given an opportunity for the board to comment to the board regarding that particular rule or the proposed rule change. Then after the decision is made, at that meeting, the board makes a decision in open session regarding that particular rule, and then formal notice must be sent to the owners again regarding what decision the board made regarding that rule, and another copy of the new rule must be sent in that notice for it to be effective. So in general, Ukiah is more specific. If you aren't a Ukiah community now, best practice would be to start complying with it just to make sure that you're familiar with what you have to do when it becomes effective January 1st, 2028. Ken, do you have anything to add to that?
Yeah, in terms of the the person who wrote the question, essentially saying the board is doing things they can't stop them. In all communities, the membership does have the ability to remove board members. You know, there are provisions for calling special meetings and letting the membership vote out a board member who they don't think should be serving any longer. So that is an ultimate power which the community does have. And you know, I think Jennifer covered that if rules are not written down and distributed to the owners, they're certainly not enforceable. So the board can't just announce at a meeting that you can't park a boat on your front lawn and then have that be an effective rule that they could enforce. If they mailed out notice of a rule that you can't park a boat on your front lawn, then becomes enforceable. The other comment I'd make is that rules cannot conflict with the governing documents. So rules are a clarification of what is contained within the documents. And our preference, of course, is that the authority to draft rules is actually clearly stated. So the association can adopt rules regarding use of common areas, and that I think is provided in statute. So the association can do that, meaning the board can do that. But those are my thoughts.
I'd like to add one other thing. Ken, you just reminded me of something. One thing that I've seen a lot for associations is to have the assumption that if the declaration doesn't say you can't do something, it means you can do something. And one of the ways we see this a lot is the rules will state that an owner is responsible for damage they cause when that's not addressed at all in the declaration. How that works is that your rule conflicts with the declaration. The authority for that particular thing must be in the declaration for it to be effective, especially if it regards how the property is used and an owner's rights and obligations. So if the declaration is silent, the assumption is you can't do whatever that particular thing is. Did you want to add anything to that, Ken?
Well, I certainly agree with that as it relates to efforts by communities to make owners pay for damage within the insurance deductible or that they have caused to the building. And you're right that there's a conflict between often the damage and destruction provision within a condo declaration and what people think should be fair or should be, just because they think someone who does something bad should pay for it. And that's fine, except that the governing documents often prescribe a different way of handling the expenses, and it is as a community that you pay for it. So, yeah, people can ask more questions on that, I guess. Second question is regarding the upcoming Corporate Transparency Act. What's your legal opinion about whether or not homeowners associations should amend their bylaws or rules and regulations to require directors to comply with the corporate filing regulations? Would you recommend boards declare a director's position vacant in the event they refuse to comply? So, of course, we're not giving legal advice here. It's going to depend on the specifics of your situation. But generally, we would recommend that boards amend their declarations so that they would have the ability to remove a board member who doesn't comply with any law. It's sort of interesting that there is no way to remove a board member absent the proper procedure by the association calling a meeting and voting them off for theft or for failure to comply with the governing documents or failure to comply with something like the CTA. So you don't have, as a board, the ability to determine the qualifications of board members, which would include whether they have complied with this new federal law. Owners can do that, but only owners. And maybe, Chelsea, if you want, you can stick in the chat the 3 RCW numbers, which basically state very specifically board members don't get to decide qualifications for board members. That's a right and privilege reserved for the membership as a whole. Anything you want to add to that, Jennifer?
No, I think you covered it. So the next question, under 6434-384 reserve account. So this is the new act for condominiums. And this in particular is regarding the reserve account. Withdrawals says withdrawals from reserves can be made for major maintenance, repair, or replacement of reserve components out of cycle with the reserve study. Under 6490-540 says withdrawals from the reserve account can be made for replacement of costs of reserve components not included in the reserve study. It seems that 6490-540 is more restrictive as to what reserve borrowing can be used for, as it limits withdrawals for replacement costs and not maintenance or repair of reserve components. Is this a fair reading? So the answer here is not really. So we would read these two particular statutes as being similar because we believe the legislative intent was the same. It's just poorly written. So 6490-540 sub 2 is the precise citation. It says the board may withdraw funds from the reserve account without satisfying the notification of repayment requirements under this section to pay for replacement costs of reserve components not included in the reserve study. So the emphasis there should be on the not included in the reserve study. What 6490-540 sub 2 seems to be implying is that maintenance and repair of reserve components can be made out of the reserve fund at any time without notice requirements. So the general purpose behind this statute is to require associations to give owners notice of when they're using reserve funds out of cycle, potentially, or for non-reserve components or general spending. So replacement of reserve components not in the reserve study doesn't require notice, doesn't have the notice requirements required for spending for a general purpose. After they are replaced, the component should be included in the reserve study. So there's no case law on 6490-540 yet, but we would interpret this particular statute to mean that if you have to maintain, repair a reserve component, you can use reserve funds for that if you are without giving notice to your owners and then having a repayment schedule as required in the prior section of that statute. But if you're using it for something that should be included in the reserve study but wasn't, you can use those funds, but then you must add that particular component to the reserve study. Ken, did you have anything to add to that?
Yeah, the origin of this statute in the current Condo Act came in 2012, and I was on the Legislative Action Committee when this statute was being prepared and handed to the legislature. The problem is that there are frequently building repairs or replacements that become required that were not included in a reserve study. And it is a surprisingly common event. And so the intent of the one sentence was that we don't care whether the reserve study included the building component. You can still use reserve funds for that building component. And I'm not sure why over the last 12 years, we've had so many people try to twist this into making it a requirement that if you spend money on a reserve component that the reserve study did not anticipate, you're required to go through this process of notice and refunding. And I just don't think that was the intent when we wrote the law in 2012. And so I don't think you should try and find ways to make it more difficult to repair your building using reserve funds. You know, I've got a client that recently has had to replace their fire sprinkler system, which was never included in a reserve study. And another building that has discovered that their piping was a polybutylene, which is a product which was used for about a decade back in the 80s and early 90s. And then the plumbing code removed it from being an acceptable product because of the number of failures that were occurring. So they're now looking at having to replace their plumbing. none of which was included in the reserve study. So they can use the reserve funds to repair their polybutylene plumbing. They can use the reserve funds to replace their polybutylene plumbing, because those are building components that the reserve fund is intended for, even if they're not in the study. Anything else you want to add, Jennifer?
No.
Okay. So the next question actually was put here by one of our attorneys in our office, and her question was, I've had at least 5 board meeting minutes where the board is approving a foreclosure lawsuit, which is now a specific requirement under the statute. But the decision was made in an executive session, not the general session. And it was not specific as to which unit they were approving a foreclosure for, or what actually they were approving. And so the attorney wants to know if this should be a Q&A topic, because the attorney's opinion is that the decisions need to be reflected in the regular board meeting minutes in order for us to do a foreclosure for the client. And so we know that the open meeting statute specifically states that decisions are not made in executive session. The board can discuss a matter in executive session, and then they go back into an open regular meeting and they make a motion and vote during the open regular meeting. So our answer is that it should be reflected in the meeting minutes, and it should be reflecting the specific unit or account number for which account is being foreclosed on, so that it is clear in the meeting minutes. And we understand people's desire to, be protecting, privacy of individuals, but there is no statute which provides for the privacy of a delinquent owner in the revealing that they are delinquent and that their home may be foreclosed on. And I actually think it's more likely you're going to get a resolution and payment if you do make sure that the owner has that information available in the meeting minutes, or their neighbors might even know and figure out what's going on and get the assessments paid. You don't have to identify the name of the person in the meeting minutes, but you do have to have enough information that an owner could identify themselves, or you need to identify the lot number or unit number. Anything you want to add, Jennifer?
No, I think you covered it. And we're definitely going to run out of questions. So if anyone has a question, please add it to the chat and we will get to it once we've finished the answers that we've prepared. So our next question. Does an association need to get homeowner permission to use pictures of owners on the association website or in the newsletter? So I did a quick search for statute on this, and there was none. We're aware of no laws that prohibit photographs of people being taken in or from public places. So in the common areas, there's really no expectation of privacy there. We are aware of no laws that prohibit use of those photos, but if you're using a photo of someone and that person is identifiable, best practice, and just, it's polite to ask. If the photo is of a group and no one individual is really identifiable, then that's probably fine. Photos of an individual close up, ask. This is more of a politeness thing. But honestly, if you have a question about it, just ask. It's always easier to get permission than to publish something and have it come around and bite you in the rear. If the association, if the photo is posted on a closed section of the association website, that might be different. But again, it's easier and quicker to just ask rather than post something and have someone complain that their privacy has been violated. Ken, did you have anything to add to that?
No, it's the privacy violation is a perception more than a legal right, but it's still something we would prefer you just not have quarrels with your community members. Next question, is there any reason to support tenants receiving or not receiving newsletters and or phone directories? So I'm a little unclear on the question about whether they're talking about all residents in a community or just about people who rent in a community, which would be the tenants. But newsletters and the phone listings are going to have two different standards, in my view. You're not allowed to give out phone numbers. So if you're creating a phone directory for your community, it's with the permission of the people who are in the phone listing or phone book. And we do have clients that produce, because they are, very social communities, listings of all of the people who live in the community and their phone numbers and emails so that owners can communicate with one another. And I think that it probably, in that case, it's up to the community whether you want to include both an owner and a tenant, but you would need the permission from both of them to list their phone numbers. In terms of a newsletter, we would certainly support trying to make sure every resident is informed about what's going on in your community. If you're doing work like, repainting your parking spaces, you want the people who live there to be aware of it. And you're not violating any kind of privacy rights by informing the people who live there, including the tenants, about what's going on in the community. So part of it is, there's a reasonableness standard for whether or not you'd include the tenants or not. If you're putting up signs and posting notices because you need everyone in the building or the community to know what's going on, I would certainly include the tenants in those notifications. And if the newsletter is the way you're doing it, I would use that as well. So anything you want to add, Jennifer?
No. And our last prepared question, and I scrolled oddly, I'm sorry. Is there anything in a unit's lot file that should be kept longer than 7 years? So the statutory reference for this, and this is in the record statute, is 6434-372, 6438-045, and 6490-495. The answer may depend on whether you're talking about a current owner or a former owner. But typically we would recommend keeping maintenance records or modification records. The statute does state that the board must keep information that they use to rely on to make a to respond to a modification request for 7 years. After that, that information can be destroyed, but we would keep the information of what modification was done for as long as the unit is there. Property records or maintenance records regarding the unit probably should be kept because you may need that information later. Information regarding a particular owner probably is, you can get rid of it and follow the records retention statute, or once the owner sells, you can probably get rid of it. But the unit is there, modifications made to the unit that are still in place, we would keep that longer just so that you have that information available. Ken, did you have anything to add to that?
Just to add to that, if you're modifying plumbing and electrical systems in a condo building, you would like to have a permanent record of those changes. If you're modifying drainage systems on lots in an HOA, that may be something also that you'd want to have a permanent record of. In the same way that, the county or city keeps records of maintenance, modifications to sewer lines and electrical systems, etc. So that's all I had. Are there questions then that have come in on the chat, Chelsea?
There are indeed. First one is, a neighbor's dog is apparently being neglected. This is based on dog barking at passersby outside the fence yard, whining and crying at night, and other signs of distress. What action is appropriate for the HOA board, if any? We have a no nuisance rule for pets, but nothing about observations of neglect of a dog.
Ken, do you want me to start with that, or do you want to?
Sure, you can start.
Okay, so the nuisance provision in the governing documents also relates to dogs creating noise, even if it's noise of distress. So you can submit a complaint to the association manager, or have the board do an investigation to see if the noise created by this dog is unreasonable. If the noise is happening in quiet hours, call animal control. There are steps that can be taken to deal with this particular issue. According to your enforcement provisions of your governing documents, you can also always call animal control, or whatever city or county resources you have available to see if this dog is being neglected and what can be done about it.
Yeah, I guess I would agree that animal control is an objective way of determining whether or not the dog actually is being neglected. And you could certainly, I say, broadly define a nuisance to include neglecting an animal. But I think it may be difficult for the board, without an investigation and use of objective information, to make a determination that there actually is a problem. And so getting the government involved to try and make that determination is probably an easier thing to do. Next question, Chelsea.
All right. If a Wakaiowa association mailed out a policy or rules and regulations, etc., allowed for the required comment period, and then formally adopted the policy at their board meeting as planned with no edits, is it necessary to mail the policy to owners again?
I'm going to say yes.
Yeah, I just looked up the statute again. It's 6490-505 sub 2. And the statute does state that the approved rule or policy, whatever language you're using, does need to be sent out again.
Ready for the next?
Yes.
Sure.
Okay. Condo that is 6432. Does there need to be an owner's vote to use reserve funds on an item that is not identified as a reserve item, i.e. repairs needed inside a unit caused by the building's plumbing stack?
So I'll take a first stab at this. The first is that there is, I would say, never a vote of the owners, meaning the membership, to spend reserve funds. The reserve funds are put into the reserve account through the budget process, but the board of directors alone gets to decide how the reserve funds are used. But the question described performing repairs to damage inside a unit, which is different than replacement of a reserve component. And so I would be looking at the insurance provisions and the damage and destruction provisions in the condo documents to determine whether or not the the repair is the responsibility of the association. And if you're talking about restoring the damage rather than restoring the building component, then you're going to get into a a question about whether or not use of reserve funds is appropriate or not. And it's going to get very specific, and you're probably going to need a legal opinion. If you're looking at spending a lot of money restoring a unit, then I think you may be crossing the boundary from it being a reserve repair into it being something that should have come out of your insurance. What do they call it? Insurance reserves, because a lot of associations do have insurance reserves. Or it may be something, it's an unbudgeted expense you need to find a way to deal with. That may be the kind of an expense that you would have to notify the owners and have a plan for repaying within 2 years, unless it would be an undue burden on the membership. Jennifer, you got any thoughts on that?
Just briefly, and this is mostly for the difference between maintenance and damage. We get a lot of questions, especially in the rainy season, regarding who's responsible for what. Maintenance is different from damage and has to be treated differently. They're two completely separate sections of the declaration. If you have questions on whether or not the association is responsible for a particular damage expense, it's worth the $300 to $500 to get a legal opinion and know exactly what the association is responsible for, rather than winding up with an angry owner because repairs haven't happened yet. And then you're being faced with, oh my gosh, is the association responsible? The association's responsible for this and we can't pay for it. So we're getting questions all the time. Right now I'm dealing with one from the freeze back in January about who's responsible to restore the unit. Get the legal opinion. Honestly, it's money well spent, so you know what your documents say, and you know whether or not you need to change what your documents say in order to not have these huge expenses in the future.
I'm going to add a quick pitch to this. The amount of money that you would spend on legal advice to deal with these damage events is really small compared to what you're paying the plumbers and what you're paying to the water mitigation contractors and what you're paying to the restoration contractors. And, you know, we must have had, I don't know, I'm guessing close to a dozen inquiries come in during the summer about frozen pipes that occurred in January of this year. And this is a dozen clients at least who waited somewhere between 5 and 7 months to contact us when they had already spent, in most cases, $25,000 to $50,000 on doing emergency repairs and restoration work. And, you know, we are cheap compared to the plumbers and the companies that come out to put fans up in the unit to dry it out. And I think that more clients could save a lot of that money if they would get an opinion early instead of waiting until 7 months after the fact. So.
And I would also point out several of these associations are looking at either not being renewed by their insurance company or massive increases in their premiums because of the language in their documents. And they've been doing insurance and damage wrong for years. So Chelsea, next question, please. You're muted.
Still muted.
All right.
There you go.
We have several clients that are in extremely one-sided contracts with elevator companies. These contracts were in place before we became managers. We are consistently seeing proposals for work that's outrageous. For example, we received a proposal to clean construction debris from an elevator hoistway for $16,500. Another more trusted contractor provided a quote for $700 for the same work. Besides never sign contracts that would prevent competitive bidding, what other options do HOAs to not be forced to accept over-the-top quotes that the vendor insists we are contractually obligated to accept their bids? An L&I inspector advised me that there are state laws stating that we do not have to get work done with any specific elevator company, regardless of the contract. Is that true?
So I have not researched, I don't think our office has researched whether or not there are state laws that would impact the contracts which the elevator clients sign. There's no question that the elevator industry has contracts that are ultra favorable to the vendor and really poor for the clients. They almost always include 5-year terms with automatic renewal and a window of opportunity to cancel, which is so short that none of our clients ever meet it. One of the options is always to effectively breach your contract. You can just refuse to pay the contractor. You can change the locks on the elevator equipment room so that your new vendor can go in and do it and your old vendor is locked out. But there are risks associated with that because you've got a written contract which you're now in breach of. And most of the contracts do not say what the consequences are of a breach of the contract or termination outside of the standard 5-year window of opportunity. So you probably do need to get an attorney to help you analyze what the risk is. We have worked with clients where they have unilaterally terminated even though the contract stated something different. And the state law would usually provide that if you breach a contract like that, the maximum that the vendor is entitled to is going to be their lost overhead and profit because they're not spending money to perform. They're not entitled to the full amount of the contract sum, which would have provided for performance. So, we can't answer a question about the 16,000 versus 700. It probably has a difference in the scope of work. I don't know what the difference in the scope of work is, but that's part of what is likely to be the difference. And I have no idea whether or not you need to use an elevator mechanic to do the cleanup of construction debris. I also don't know how you ended up with construction debris in your elevator hoistway. So there's a lot of variables there, but elevator contracts for Comcast or other cable services usually have very long terms. And we routinely, when these contracts come to us, strike the 5-year terms and move it to a 1-year term. And we try and put a month-to-month extension on all these contracts instead of terms even of 1 year, so that if you're, as a client, become unhappy with the vendor, once the original term is over, you're only required to wait a month to move on to a new vendor. Anything you want to add, Jennifer?
Just briefly, a lot of associations will enter into contracts like this without having legal review. Legal review is cheap with regard to particular contracts, especially these large number contracts like elevators or construction. Having it reviewed, knowing what the terms are, and knowing ahead of time what you are bound to do, that level of information is cheap compared to having a problem and then going, what can we do with this after you've already signed it and are in the contract?
Yeah, I'll add for some contracts, and elevators are a good example. You you are buying a service contract to maintain the elevator, and it is reasonable that different contractors not come in and perform work on the elevator while you are relying on one company to essentially ensure that the elevator is going to function properly. So it's not unreasonable for the vendor to have restrictions on outside vendors. What I do think becomes unreasonable is if you're trying to modernize your elevator and the vendor says, well, you can't go get bids from anybody else. And we certainly have told a number of clients, go get bids from other people, because if you get a different vendor who will come in and service it, then it's worth breaking the contract with the first vendor. Anyway, Chelsea, you got any more?
Yes. Two owners have started a newsletter, which they're calling the Village Voice. Our HOA name includes Village, and the board have explicitly asked that they do not use that title. They put a printed copy of the newsletter in everyone's mailboxes. Does the board have any basis to object?
Well, I'm going to offer that there's probably no legal basis to object. We've certainly seen individual owners who have created websites using the name of the association. If you haven't trademarked a name, then probably you are not going to be able to do anything. And the owners can certainly, with a small tweak to the name of their newsletter, differentiate it from something which is a sanctioned community newsletter. So I don't know that there's a great answer. You probably are starting to look at other options like a competing newsletter that you might put out, which would give information the board would think is appropriate. Jennifer, do you have any thoughts?
Not well. When you get into a situation like this, and my assumption is that the owners are in opposition to the board on any particular topic, you get the appearance of having to fight with them. It makes more sense and is easier to just put the actual information, correct information out there and let these particular owners try to do whatever they want to. The typically something like this will die out over time, especially when the board is being reasonable, but these owners are not.
Yeah, and I would remember that most of these newsletters are going straight into the recycling bin. Chelsea?
Any tricks or tips for dealing with one homeowner who requires a substantial amount of time for the board? Also, this person is a self-appointed specific committee lead and causes a lot of strife there as well.
Well, my suggestion is usually to try and control how communications come to the board and when the board deals with them. So I like a policy where boards deal with issues only at board meetings, because that's the only time that they really have authority to. They deal with issues only where they have been given adequate time to investigate and get facts upon which to make any decision. So we actually have communication policies we prepare where if an owner sends in a complaint, a question, a recommendation, a demand, whatever it is, it just waits to the next board meeting. If they've presented it 7 or 10 days in advance of the board meeting, it'll be put on the agenda for the meeting. Just because it's on the agenda doesn't mean it's actually going to get dealt with every time. But the idea then is also that once the board deals with it at the board meeting, they will respond back to the owner. And you don't have to be answering every email immediately. You don't have to work on timelines dictated by the owners, but you do have a routine process of meeting with the board and making decisions And that's something which you should be able to say to an owner is the timeline that the board's going to work on, and then stick to it. So, Jennifer, any thoughts?
One thing, the question or comment says something about the that particular owner being a self-appointed committee lead. The board is the entity who can create and disband committees. The board also has the ability to remove committee members or remove a committee lead. If this person is causing that many problems in a board sanctioned, a board set up committee, remove them. You have that authority. So when you have a particularly troublesome owner, you can remove them from authority. You can set up the communication policy where the board only deals with their particular agenda at board meetings. There are ways to curtail how much time is spent on this particular person. And honestly, we have at least 3 that I'm aware of people where the only communication to the management company for that particular person is through our office because they're that much of a problem. So if you're having someone that is that troublesome, talk with your community association attorney to get an idea of what you can do. If you've already tried everything that you can, we're the big stick.
Yeah, I guess there are owners where the answer is you just don't deal with them at all. And we've had a couple where if their attorney doesn't contact us, nothing is done. Chelsea?
If there is nothing in the bylaws about owners not being eligible due to delinquencies or violations, can those owners who have violations or are delinquent in assessments be nominated to serve on the board? This is an HOA community.
My answer is yes, they can be nominated to serve on the board. And if the community wants to elect delinquent owners or owners in violation, they have that right.
Unless this is one of those areas where unless the governing documents specifically state that something can't, that owners who are delinquent or are in violation can't serve, they can.
All right, next question. Follow up on records. We have records of a foreclosure that was not completed from many years ago. Should we keep it?
Well, I'd say if it's more than 7 years old, I'd throw it away.
If the case itself is probably gone. If the owner is still there, the fact that they were delinquent 7 years ago, if they're current now, there's no reason to keep it.
And certainly if the owner changed, there'd be no reason to keep it.
All right. We had condo law create a maintenance matrix for us. It has saved our bacon a number of times with who is responsible for what. But we do send them specifics about each damage issue so they can help us with the determination. That is not a question, that's a statement. Thank you. All right, so next question. Does Ken have time to discuss enforcement in general? Although the board's duty includes enforcing the provisions of the governing documents, must board members always be in enforcement mode? Always enforce every rule, whether or not anyone has complained? Does the board of directors decide when and how to enforce?
I think that RCW 6490-405, I think it's subsections 7, 8, and 9, is specific to the board's discretion in how they enforce the rules and regulations. The board is not expected to be the HOA police. You do not have to go out and seek every violation that may be occurring in the community and enforce it strictly. And that particular statute, I think, does a good job of providing for what case law, meaning the courts, have determined is appropriate for boards. You do not have to enforce every rule strictly. A failure to enforce a provision does not mean it cannot be enforced in the future or for other circumstances. And there is a reasonableness factor that the boards can apply, meaning if they think a violation is not significant or it's just not in the best interest of the community to try and enforce, then they can exercise that discretion. Any thoughts, Jennifer?
Just briefly, this, the authorization and statute for the board to pick and choose, that's not exactly the word that I want, but, what violations are appropriate to enforce and which aren't, cannot be used to discriminate or to, pick out one particular owner and ignore everyone else. You have the discretion to choose which violations are important to you, but it must be uniform in application. You cannot discriminate, you cannot, and I'm going to use an example from a community that an owner was talking to me about a month ago. In the past, they had board members who would say, oh, I like so-and-so, their hedge is a little too high, whatever. But so-and-so is a complete jerk and their hedge is 3 inches too tall. Send them a warning notice. That's unequal enforcement. It's prohibited by statute. It's discrimination. And opens the association up for a lawsuit. Don't do that. If it's something like, okay, hedges that are under 6 inches too tall, we ignore it. If someone complains, then we can send a warning notice and that's applied uniformly. That's perfectly fine. It's just be careful on how you use your enforcement authority.
Yeah, so I think it's reasonable for most boards to be reactive in their enforcement, meaning if complaints come in, they enforce them. I think it's reasonable to have some kind of, I'll say, routine compliance review. So we certainly have some clients where once a month or once a year, the manager or board will go around through the community and from the public spaces observe whether or not there are violations that they should be concerned about. And they, but otherwise, one of the things you can remember is that every individual owner in the community also has the right and authority to enforce the CC&Rs or the condo declarations. So if one neighbor does not feel like the board is making the right decisions or the board is not enforcing strictly enough, that owner has the authority to go to court and enforce the CC&Rs independently. And so we do try and recommend that boards stay out of disputes between two neighbors. So if the hedge Jennifer was talking about was just between two lots and it was a 3-inch difference, then I think it might be reasonable for the board to just stay out of it and let the two neighbors work it out on their own. So I think that that's probably enough for today. And if you've got other questions, please get them to info@condolaw.net and we will try and cover them next week. So, thank you, everyone.
Good day, everyone.